So the question, and it's I'll rephrase it, and if you don't mind, and tell me if I got it wrong. A lot of people have been burned with class action lawsuits, or have a bad sense of class action lawsuits because the result of them is, you know, a coupon to Arby's for $6, or, you know, some nonsense like that. Well, first off, that I would say, in fairness, probably reflects the amount of injury in some regard of that particular class. You got something in the mail, you probably never knew you had a problem, and all of a sudden I get this useless nonsense. Yeah, exactly. And so, you know, I concede that there are many class cases where you get not a lot of utility out of it. In this particular case, I would say that the easy answer to your question is your injury is much more than some $6, you know, coupon to Arby's. Okay, so it's impossible for it to result in that way, I think. But even better, the government isn't. There's no other form of relief that it can give, because a lot of times what happens when you sue a company like that from a class basis is they'll say, well, we'll provide this additional service, we'll do these other things, we'll repair, we'll change, whatever. There's not really an option here, you know, and the only relief that can be had is cash, is payment. So that's the point. But to your point though, again, remember the class that we have contemplated, we haven't moved for it yet, and there's lots of steps between now and then, but the class we have contemplated is in this liability phase. I'm planning on, in sort of, you know, bringing the forces together here, I'm planning on being able to prove damages on an individualized basis. I will look hard at asking the court to see if there's a damages class that we can put together, or if there's a way to prove up damages on a more sort of macro level, like, you know, for the diminution of value, for example, in a neighborhood by neighborhood basis, something like that, you know, to make it a little easier for us to get through it. But our undertaking here when we sign with us is that we will prove your damages on an individual basis. And so it's really important. You hear these comparisons between, oh, that's the class team and this is the individual lawyer, or an individual, you know, what the class. The class is just, right now, that's contemplated is just on that liability phase. And we are planning on damages. We're gearing up to be able to do it individually. Does that answer your question?
Yeah, just to follow up, what's the wisdom of going up to two reservoirs in one lawsuit?
Oh, well, because they're designed to work together, you know, and so, I mean, fundamentally, if they were connected, it would be no different. They just made the space for I-10. I mean, really, you know, so the decision-making process, the planning from day one, the first day, the first spade in the ground, the plan was always to have at least these two.
Yeah, I mean, these just to show you, this is Addicts. Red is the federal government land that they own. The dam goes around the right-hand side and along the bottom. The area we have outlined in blue is the inundated pool area, right? So, and then this is Barker. Same thing. They just didn't buy enough land to contain the pool. Now, the theoretical pool is bigger than that, but the two reservoirs outside of the physical location and the elevation of the pool worked identically the same. Okay.
I wanted to add on to this whole issue of class action versus individual. The lawsuit that we brought is on behalf of the individuals that we named. Well, I think we have a dozen people who we have sued the federal government on their behalf, individually. No different than the other, quote, lawsuits of individuals. No different at all. They are exactly the same kind of suit, except for one thing. We have taken the additional step to say, if we are successful for one or more of those 12 people, we want the court then to say that everybody else who's in the same situation as one or more of those people also can be compensated. The other lawsuit's not saying that.
Right. That ties it into a class. Yeah.
Correct. And that's the reason to bring a class. And that's why we're doing it. We're not doing this lawsuit just for our clients only. Because we realize everybody's in the same boat. And we just frankly think it makes more sense, fairer, and we're kind of doing that for the whole community.
And there's one more unique aspect on the class issue for this particular court, and that's usually in those types of cases where you get the coupon in the mail, the default is you're in the class unless you pull yourself out. Okay? In this case, the rules of this court are you opt into the class. So you'll get, when there's a class that gets certified, you'll get a notice and it says, hey, good news, the class got certified, and if you say yes, then you take part in the benefit of all that work we've done. And we've got hundreds of clients signed up individually. We've used, it's actually 13 baker's dozen, I'm not going to say it's unlucky, but it's a baker's dozen of clients that we've tried to spread around to have sort of geographic diversity and also typicality. So there's like a landlord, there's a tenant, there's a business, you know, to try and get everybody covered. The people that were not listed, our plan is to not opt them into the class until the class gets certified, because you want to sit on the sideline on the class question until you know that the class worked out. But the difference is, for those people that sign with us, we're going to try and push their damage analysis forward. And that's why we're going to be doing the individual work on the damages to try and get to the end goal. Sir, you've been waiting.
One is, you referenced, you said you sued the court before. This is a yes or no explanation. Did you win or not?
Yes, the federal judge agreed with us that the core analysis of the impact of Highway 99 on Addicks Reservoir was insufficient and ordered them to go back and do it again. We were unable to stop Highway 99 going in, so they started construction, but the court did have to go back in and admit that we were right. They failed to analyze it, and they had to redo it and come up with some different conclusions.
And the second is, reference, this is probably good, but more likely, design flood pool. When we moved in, we've been in our home in Lake St. 20 years. We were told we're in a 500-year flood plain. What the hell does that mean? Is this the 500th year we just got screwed?
The question is,
and how does that
right.
How does that align with the design floodplain, what they didn't buy, everything like that?
Correct. Right. So the question basically is, you've heard of the 100-year floodplain, the 500-year floodplain, the 100-year flood pool, the 500-year flood pool, the maximum design pool, the Harvey pool, the federal government-owned land pool, all that stuff. Basically, what does all that mean, essentially? Hopefully everybody understands what a 100-year floodplain is. You'll see that on floodplain maps, and it basically just means it's the area that would expect to be inundated during a 100-year storm event. What does a 100-year storm event mean? Well, it's that storm that on average would be expected to occur on average once every 100 years, which also means that it has a 1% chance of occurring every year. Okay? We have been lucky or unlucky in having probably 3 500-year events in the last 3 years. And the National Weather Service has actually recently come out with updated rainfall information that shows that our rainfall around here is a lot higher than we had originally thought would be for a 100-year event. So for these flood pools, these dams and the water behind them, we call that a pool instead of a floodplain. Essentially, it's the same thing. So you have a 100-year flood pool behind each dam, which is that level of water in that area that would be expected to be inundated on average once every 100 years.
Is that the red?
Yes. Okay. And generally, the federal government bought that land. That's the land they generally own, is associated with about the 100-year flood pool. Not exactly, but close. Then there's a 500-year flood pool, just like a 500-year flood plain. That is also shown on floodplain maps, FEMA floodplain maps. That's the additional inundation that would occur for a bigger storm, one that would be expected to occur on average once every 500 years. But again, every year it has a 0.2% chance of occurring.
What is the blue?
No, it's just a little bit bigger. Harvey was bigger than that. Okay, Harvey's been estimated to be about a 1,000-year event. Okay, and so it inundated more land than the 500-year. Okay, to give you an idea, the 100-year pool is based on about 13 inches of rain in a day. 500-year pool, about 18 inches of rain in a day. Harvey was 30 inches of rain total. The maximum design pool is based on 45 inches of rain. Okay? So you only had 30 inches of rain. Well, 50 not here. 50 was over on the southeast side of Houston, kind of in the LaPorte area. Okay? And so that's how these different levels get reached and get calculated and get mapped. And that's why we're saying this, the government, Corps of Engineers, the federal government, assumed that the maximum amount of rain they could expect behind these dams would be about 45 inches of rain that would occur over 3 days. And they calculated the water level for it. And that's the 115 for Addicks, it's the 108 for Barker. And that's how high they expected the water level to get behind their dams.
And I guess the key thing, the key takeaway is, until very recently, all developers were required to do was to build with respect to the 100-year floodplain. They had to build a certain elevation above the 100-year floodplain. Well, here we have dams where the 100-year floodplain is almost entirely on federal government property, so of course no one's building there. So the developers outside of that, they were never required to build to a standard that anticipated, 115 foot of water elevation in Addicks Reservoir. Also, the concept of, why wasn't I told to get flood insurance if I'm built in a reservoir? Because the whole flood insurance program is not really designed to handle the concept of homes built in a reservoir. It's designed to handle the concept of people living along water courses where there's a 100-year floodplain and there's a 500-year floodplain. Everybody is outside the 100-year floodplain. So no bank is going to say when you go for a mortgage, you have to get flood insurance. That's why so many people didn't have it.
But we were told we're in a 500-year floodplain. We don't need it.
Yeah, if you're in the 500-year floodplain, you don't need it. And I mean, here's the floodplains. The blue is the 100-year floodplain. This is Lakes on Eldridge. The brown is the 500-year floodplain. The hashed line is the floodway, and is that Horsepen? Yeah, that's Horsepen. And you can see there's some areas of the subdivision that are in the 500-year floodplain up there, but most of the subdivision is even outside the 500-year floodplain. But until, Harris County and very recently the city of Houston, I think on Friday, started saying, we're now going to require people to think about the 500-year floodplain. I mean, the new regulations are, you got to elevate 24 inches above the 500-year floodplain. The old regulations were what, 18 inches above the 100-year floodplain? So imagine the difference. That's going to be a big difference. A lot of your homes would have been a lot higher if we built to the 500-year floodplain. But even the 500-year floodplain wouldn't have saved you from Hurricane Harvey, right? Because it's a reservoir. It's designed to hold, what, 1,000-year rain? A 2,000-year rain?
10,000.
10,000-year rain.
Well, if it had been the 100-foot pool, 150 feet, no.
Yeah.
Yeah.
Ma'am, you asked a question.
Yes, 2 parts. One on damages from a different perspective. And that is damages that we really haven't seen yet. The air conditioner's not going to last as long as it should have. The driveway's going to, the settling because of all the water.
Absolutely.
If you could address that, and also if you could just say a word or two, if you did have flood insurance, how that all gets merged together.
Sure. So in the first part, that goes back to the fact that we have probably the best authority on flood damages out there, and they will have it through their experience, a list of all the different types of injuries. For example, I've got a theory, I'm not sure I think it's good, that even the places that are inundated, okay, it softens. But I'll use a better example. Lakes Eldridge is a client, the HOA, okay? They own their own roads. I think, as I understand from the engineering side of things, when the land underneath the roads gets softened, the roads will subside. That causes damage to the roads, okay? And so the value of those roads before the flood, as compared to the value of the roads after the floods, is part of the injury. I think that same principle probably applies to people's slabs. All right, your house will float it a little bit, will sunk a little bit, and so we are going to have experts that look at that issue. We're going to look at the law. Can we prove it up as a matter of law? Can we prove it up as a matter of fact? Can we prove it up as a theory of damages? So, you know, you're right to, you know, what about this, what about that? But that's exactly the job that we're going to be doing for you, is to try and work that out. And then, you know, we'll get input as we learn from this. Oh, well, you know, that's a great idea. Particularly, this came up a lot in the HOAs. I sat down with one, and they, well, I have this issue, like my fences, these brick fences, they're all settling and cracking. Okay, that's something else that everyone probably has, you know, and as we learn more, and as our experts tell us more, we'll have a better sort of full list, but that's absolutely the ambition. We want to identify every one of those little buckets and fill every one of those buckets up, okay, absolutely. Sir, in the back.
I had a question last night about a woman who, because of the stress of Harvey and flooding, flood insurance. Because of the stress of Harvey and flooding, she was grinding her teeth and she had to go and have a couple of $1,000s of dental work done. That is probably not a measure of damages that we can tax against the federal government. So there are things that might be typical damages in a private lawsuit against a private third party that just don't fall within the scope of takings. It's takings of your property, and takings of your real property, and takings of your personal property.
Although for people that are watching, we don't concede that.
We don't concede that, sorry, yes. All right, and the second question you had was about flood insurance. So a number of people do have flood insurance, and hopefully they did get payouts. Whether some people didn't get enough to cover their full measure of damages, other people got the full cost of repair and the cost of the contents fully reimbursed. Those latter people, they still have a measure of damages, right? Because the FEMA flood insurance isn't paying you for the permanent diminution in your property value. The fact that it's now a previously flooded home that you have to disclose to a purchaser. So that, you always have a measure of damages, even if the flood insurance paid everything. What we've seen happen in other cases is when you get a damages award for you, the court will ask, did you get flood insurance? And you say yes. And the court will say, how much did you get? And then that will be subtracted out of your damages, because that money is already coming from the federal purse. So you don't get to double dip against the federal government. In fact, you don't even get to double dip against private insurance. You know, like insurance companies will come after you if you file a lawsuit that they've paid out on your claim. So that's just a general concept. We're not saying it will happen here, but it's what we've seen in other similar cases. However, in other similar cases, we've seen things like FEMA grants and SBA loans not get subtracted out of your damages award. An SBA loan, that's federal money, but you have to pay it all back. A FEMA grant, the few people that got some money from FEMA, the FEMA grant, that's your money, it's not conditioned upon anything, you can do what you want with it, and so that's your money. So that's kind of how we think the insurance will probably play out.
But we are going to try and fight to maximize your recovery in every regard, I promise you that.
Yes.
Sure. Oh, I'm sorry, let me come over here, yeah. Sir in the front.
Yeah, I have a question. We're talking about deep pockets with the feds, I understand this, but don't the cities, the counties, and the developers and these other people have just as much responsibility for what happened to us? Because they allowed it to be developed and they get the taxes off of it.
So the question is why just to the federal government? What about counties and local governments and developers? There are cases on file even today against developers for sure, and I know there's people that are looking at other cases against developers, and I believe there's probably cases on file even including Harris County Flood Control. You can only sue the government in the Court of Federal Claims, and you can you can only sue the federal government in the Court of Federal Claims, and you can sue only the government in the Court of Federal Claims, meaning like where we are in this case is just against the U.S. government. That's it, period. And while we are hearing lots of stories about my developer did this or that, and we're taking that in, I encourage everyone you should talk to someone else. I mean, you should keep listening. If you hear about a lawsuit that you think makes sense for your certain situation, I encourage you to chase after that as well. But this case here is just against the federal government because of where we are, just the venue alone.
And part of that is also that state law has a number of obstacles, significant obstacles, that prevent or hamper your lawsuit against, for example, Harris County or Harris County Flood Control. Larry was part of litigation against Harris County Flood Control for the 1991 floods on White Oak Bayou. 98. And that case was litigated for 17 years before the Texas Supreme Court says, nope, you don't get to sue Harris County Flood Control even when they know what they're doing is causing flooding downstream. So there are various state law doctrines, statute of limitations. If your subdivision was built too long ago, they're big problems because you're bringing them in state court under state law. This is in federal court, it's under federal law, constitutional law. Yeah.
Are there any conversations about condemnations?
Not that I've heard, no. I mean, we are carefully monitoring what is going on in the legislature. We know that there's disaster bills, but that doesn't appear to have any money for, compensating or for, coming in and condemning. I don't think there's a political reality in which over 10,000 homes get condemned at once, particularly in Texas. I don't see that as something that's kind of remotely feasible.
If we elect to pursue another entity in state court, can we do that if we're engaged with you to pursue the government and federal claims?
So the question was, if you elect to sue somebody else in state court, can you also sign on with us in federal court? Yes, because our engagement letter is to sue the federal government on your behalf for this particular constitutional takings claim.
That said, I would just say this, for people who have already signed up with us and that are entertaining doing that, you should contact us first to be sure that the allegations that are being made in the second case don't run afoul of the allegations in this case. You see what I mean? There is a potential for them to be saying kind of the opposite things, right. And no disrespect, but if you're not understanding exactly what the claims are, you might be doing harm to your current claim. So just, if you're signed up with somebody else, if you have a lawyer, let me say this very clearly, if you have a lawyer, you should talk to your lawyer about whether you should also sign up with us or not, okay? But that's a decision between you and your current lawyer. If you don't have a lawyer and you sign up with us, same thing. You should check with us before you sign up with another lawyer to make sure that you're not doing harm to this case. Right. Is that fair? You know what I'm saying?
And I would suggest if you're thinking of suing the city or the county, give us a call. We'd be happy to talk to you about the merits of that.
Certainly.
Yeah, I understand that we are suing the federal government, that's the choice we are making, but in the transactions that happen between, say, the builders and then the county or whoever purchased the land, did they also inherit this problem from the federal government? In other words, in the whole document, is federal government off the hook for this problem?
So, okay, well, your question changed in my mind at the last second. The first question was, aren't the people, again, the developers and the counties, don't they bear some sort of culpability for this? But maybe yes, maybe no, but and I'm not trying to be glib, but that's not our case. Ours is just against the federal government. And I guess the second part was, does the fact that the federal government may have told the builders way back when about this issue get them off the hook? In our view, the answer is no. Yeah, that's our position, because the question is, did the federal government intend to do this act that it did, and did it take property from you? And those things I think are very plainly yes.
And then follow-up question, I think earlier you mentioned about that right now you are suing on behalf of like 10 or 15 individuals, and then that also extends to the rest of the community. So if we sign up today, are we automatically part of that 15 individuals lawsuit, or that's a step two in the process?
Right, so the question there was, if someone signs up today, are they automatically part of the existing lawsuit? and if not, what happens, I think, basically. Let me address that really quickly, because the reason, as Charles pointed out, there were probably, I don't know how many cases on file, and some of them had one person, some of them had 10, some of them had 300. The reason we are down to our baker's dozen is because the court indicated very clearly, we think, that we were to select what she was calling test cases, okay? And these test cases, when we were talking to the government, the idea is to get representative cases of different situations. So that's our pick, that's our best estimate on how to best cover the waterfront, as it were. Waterfront, probably a bad analogy. And so those are the ones that selected. And there's another, anyway, that's enough for that. For the people that sign up for us, our advice to the clients that sign with us is not yet to opt into the class, because there's actually no class to opt into until a class gets certified. But we will be working on your behalf to get your damages ready, as I said, to when we get to the point of liability. The master plan here is, right, through the vehicle of these baker's dozen of claims, we achieve a liability finding for everybody. And then our clients, the several hundred clients that we have, that when we get to this point, we were going to be working on their damages, so that we get to the end, we say, government, we have liability, and we can show you exactly what our damages are right now, and we're ready. And that way, we kind of come together, we converge again, where our individual clients will merge into the class, in theory, right? Opt into the class, take advantage of that liability finding, and then show the government, here's what our damages are. That's our plan.
So in a situation where those 50, you win the case for those 50 clients, but the government doesn't agree to this being a class, what happens to us?
So it's not up to the government as to whether there's a class or not, it's up to the court. But fair enough, so the class, the question is, what happens if the class doesn't get certified, really, right? Well, at that point, there's a couple different techniques we can look to do. It's called issue preclusion. There's other mechanisms we can try that will force the government to accept whatever ruling those people get. But if it doesn't work, then we're either going to have to start trying cases by the tranche and getting through it, or go back to the court and find a better way to deal with it. My honest evaluation of this case is that it should be certified as a class for liability. I mean, I would be very surprised if it doesn't.
And this court has certified similar cases as classes before. So after Hurricane Katrina, there was a case for 35,000 people that flooded in San Bernard Parish, and the court did certify that as a class. There were 12 plaintiffs named as class representatives, and that was certified.
And the issue about a class is the person typical of the person that's being tried? The big picture concept behind a class is, if I try Charles's case, we're all in the same room, we all incur the same injury. If I try Charles's case alone, and Charles shows the court that yes, he is entitled to whatever relief, the court doesn't want to have to do your case and your case and your case. And so they certify a class to just kind of jump through that process. And that's the procedural mechanism. And so that's why we have people across a spectrum of different types of injuries and victims of the flood, to try and show what you call a typicality, that they're typical of everyone else, commonality, that their claims and their issues are common to everybody else, all right, that they're adequate representatives, and then that the lawyers are good enough. So those are the four kind of prongs that you have to prove for a class, and I feel really good about what we've done for that.
How many in this class?
Well, so we've a baker's dozen of representatives in the class itself. I think we're talking like 8,000, 10,000.
I mean, in Fort Bend County, we know because they counted, there's, 3,400 homes flooded behind Barker just in Fort Bend County. So it's probably up in the 10,000 range of properties that flooded.
If we don't want to go through flood anymore, we're in the process of buying another house.
Yeah.
Do I have to keep this property, or can I sell this
Great
property
question, Charles.
and then still participate? Because we're leaving because we don't want to go through this anymore.
No, we totally understand that. So
Repeat the question.
the question was, what happens if I sell my home? Do I have to hold on to my home in order to get some sort of reward at the end of this litigation? The answer is no. We have one class representative that already sold their home. They short sold the home And, you know, they lost money, they lost value, they lost contents, they lost value. They get to keep that claim. That claim doesn't transfer to the new owner of the property because they haven't lost any value. They paid less than what the house was formerly worth. And so we have developed a paragraph of language that we recommend that if you are going to sell your home, call us up. We will send you that paragraph that you can ask your real estate agent or the title company to drop in as an addendum to the closing documents that just clarifies that the buyer of the property is not buying your claim in the litigation. You can, if we get this resolved in 2 years' time and you sold your house tomorrow, that would be your claim, right? Because you're the one that lost the value. You're the one that had the government take that value away from you.
So if I'm just gonna use round numbers, if we sell our house for $80,000 and it's found that the house was actually worth $200,000, will they subtract that 80 from that 200?
Well, your house before the flood, you say might have been worth 200, fair market value.
Yeah.
After the flood, you sold it for 80. That is that delta, that difference. That's how much the government took from you. Because that's the best measure of fair market value, plus other damages on top of that, like the
But
contents.
it's reasonable to think that I could still get that 200.
Yeah, so let me just.
That makes sense.
Yes, it does, it totally makes sense. The question is, I think, you know, if I know what my house was worth before the flood, and I sold it for a specific dollar amount after the flood, am I entitled to get that difference, right? Conceptually, I agree with that. The question is whether the second sale is a market sale, whether it reflects the actual market value, because the question really, for the court's perspective and from what our experts are going to prove up, is market value before, market value after. So if you sold it to your cousin and got a little deal, that's not market value, okay? But that's my only limitation on what you're saying. You can't, I don't think you should look at that and say, absolutely, this is my number. But that's a pretty good indication of what your number is if in fact you sold it on the market. But it's still going to come, the question will always boil down to, what does your appraiser say was the value before, and what does your appraiser say is the value after? And then that's what you put to the court, and the court ultimately says, yeah, the expert's a little wrong, round it up here, push it down here, whatever.
Do we have to find the appraiser?
No.
That's what we're doing.
That's what we do.
Yes, sir. That's part of our.
Also importantly, if you put money into that home to repair it, to get it up to a standard where you sell it for less than it was worth before the home, that money that you put in is also part of your measure of damages. So if it costs you $100,000 to get that home back into a condition where you could sell it, then that's part of your damages as well.
I would soften that again just a little, sorry.
He's so good at this.
Yeah, well, and the point, again, it's the market value of the home as it was before the flood, and the market value of the home as it was after the flood. Now, say it was 200 and immediately after it was 100, and you put $50,000 worth of repair into it, in theory it's worth 150, and so you should get that money back. But what's really being measured is market value before, market value after, and these are different metrics, okay, and how to prove that number, okay. So that's all important information for us and stuff that the appraisers will need, but it doesn't change what's being measured. It's how you measure it, okay? Sir?
For all three of you, based on this whole event and based on what you see happening from this lawsuit, is there any reason to think that the Corps of Engineers would not do this again, would not flood us again in the future?
I tell people there is a 100% chance that your homes will flood again in the future.
Well,
I cannot tell. No, it's true. I can't tell
It
you.
doesn't matter how much they have to pay out. The benefit to the downstream people was so great that they would do exactly the same thing.
so it goes like this: as long as the reservoirs are as long as the dams are in those locations, eventually water will fill them again. Okay, there will be another storm as big as Harvey, if not bigger. When is the question, okay? And whether your home is still there, or either any of us are walking this earth or not, we don't know, okay? But as long as those dams are there, the area will flood sometime. But that, it's the question of like, once every 500 years, or every 1,000 years, or are we just so lucky? I mean, I don't know, not to get political, but there's more rain now or less rain now. I mean, there's those questions are very real. I understand, like, I follow articles a lot about floods now, obviously, and I've seen an article fairly recently where the Corps is gonna do some sort of study on how they might modify, okay, the reservoir system. And as Charles pointed out,
One of the original plans was to basically take the water and siphon it off to the south and siphon it off to the north. That never got done, so maybe they build those additions to it that will take care of the flooding, the overflow problem, okay? But until that happens, Charles is right, as long as those dams are there, it will happen again.
And, you know, probably over the next few months, you'll see various people come up with big plans. So there is a group that is looking at digging out Addicks and Barker, digging out 10 feet out of Barker and 6 feet out of Addicks, right? That plan might be feasible. We don't know yet. The Corps of Engineers hasn't studied it. Putting in a third reservoir on the Katy Prairie, that might be feasible. We don't know. The Corps hasn't studied it. But, you know, for example, digging out Addicks and Barker, you know, I've heard engineers say that it would require, if you manage to get every single excavator and truck in the United States working on that project, it would still take 10 years to complete. 10 years. So right now, as we sit here today, we have a bill that passed the House of Representatives that had $81 billion for wildfires, Maria, Irma, and Harvey. Of that $81 billion, $81 million is scheduled for studies in all of those disaster areas. And it's all very vague language, but the hope is some of that will end up in Houston studying the general flooding problem of Houston. Not just Addicks and Barker, but, you know, Judge Emmett is talking about, I want to understand all of the bayous in Houston, and that's the kind of study he's thinking about. So, you know, Addicks and Barker is one of many problems that Houston faces with respect to flooding, but right now there is no concrete plan. There may be in the future, and if there is in the future, the court may decide that, you know, the risk of future flooding is lessened, and that might be fine. But right now, there is no fixed plan. Larry's nodding his head, he agrees with me. For once.
But just to challenge that, don't you think that the magnitude of the settlement would change what the Corps does procedurally when they open the spillway? Or in other words, if this claim came to $0, yeah, they would do the same thing. Just don't open it, flood it, because we don't feel any
if they flood it
pain.
downstream more, the numbers, if they open the gates earlier,
Yeah.
then the downstream gets even worse. You know what I mean? And so,
Yeah.
it's that balance again. It's that sort of.
So you're thinking, so really magnitude of claim wouldn't make
Right.
any difference.
And actually, it's not even a balance. These two dams were authorized and built for the sole purpose of protecting downtown Houston. That is their purpose, and their only purpose. So the Corps of Engineers is never going to go and send more water downstream.
Okay.
It's just not what these things are built for. Now, that doesn't mean they're going to try to figure out other ways to minimize flooding, both upstream and downstream. And there's a study they're trying to get paid for to look into that. So it's not like they won't do anything.
Okay.
But
But it wouldn't change procedurally what they.
yeah, they're not going
they
to change their
open.
operation because their operations have already been looked at, and they only have so much capacity they can send of water they can send out of the dam. That's not a lot. It's enough to flood downstream, but it's not a lot. Not much to do really change what's going on upstream. And their view of upstream is, oh well, you know, it's just the way it is. And they've looked at the economics of what if they flood people upstream. And they concluded the economics were such that it was worth not buying all those properties or buying the easement and just waiting to get sued. Now, maybe after this lawsuit they'll change their mind.
We've been going for about an hour and a half, and some people are starting to clear out. I'm happy to answer everybody's questions, and won't leave until it's done. But before everyone starts the people that are kind of done, leave, I want to ask y'all a couple of questions, because we've been spending a lot of time trying to get outreach to y'all, and I'm curious to see who got here because of either Facebook or Twitter or through our email post. So let me ask first, Facebook, who saw it through Facebook? All right, well, okay, that's really important, because I've used a lot of time spending on that. Yeah, exactly. How about emails? Who got it through email contact?
And
All right.
how many of those who got it through email, was it direct email from us or an email forwarded from other people? Was it email from us?
Homeowners
Or
Association.
HOA or forwarded from other people? Because we want people to come to these meetings. We will keep, this is like our 9th meeting, we will keep having these meetings as long as people come and people find them useful. Because I still meet people on the upstream side who think that opening the gates caused the water to go uphill and around and flood Bear Creek. And that's not, I'm not mocking anybody for that.
It's hard to understand.
Because the timing was almost perfect, right? The pool rose at the same time into your properties as they opened the gates. So they're listening on the news about the gates opening, and suddenly they've got water downstairs. It's not, you know, there's nothing wrong with that. But, you know, we will keep having these meetings as long as people still have questions that need answering.
How about Twitter? Does anyone care about Twitter? No, I don't think so. Okay, thank you very much. Yeah, not in this room. I'm looking around. I'm like, yeah, probably not. No offense. All right, back to questions. I'm sorry.
All right,
Thank you.
back to questions.
That was just my indulgence, because I
3 in the
got a
morning.
question.
Yeah, question. So the home value for me has reduced, let's say 20% right now.
Mhm.
I joined this lawsuit. But let's say in 2 years' time, by the time when the decision is reached, my home value has increased that much. So am I still eligible to claim that loss of value as of the flooding date?
So that's going to be an argument from both sides, I'll be honest with you. We will say, as we understand it, right, it's the it's the value immediately before and the value immediately after. That is the measure. I suspect the government will try and say, oh, places recover, you know, people forget, it becomes less and less in your mind, and so the market increases, which means the price increases, but the measure as I've defined it is what the law requires, as I understand it. I mean, but to be honest with you, to be completely clear, the court might buy into their arguments and say, oh, you've overstated it, plaintiffs, you just come down here, but that's part of the fight. Our position and our understanding of the law is it's just as I said, immediately before, immediately after. So I'm talking about like waterlogged, soggy houses. That's the value, okay? Because that's when the taking ended, right? Is when there's a question about when the taking ended. Are you even back in your house? Do you have full access? All that kind of jazz. But it's the duration of the taking, and before and after.
And we are, our expert
And the
will be
property
monitoring,
yeah.
you know, sales over time to see whether they do recover. You know, I think after a normal sort of one-time random flood event, often properties will recover again as time goes on and the property doesn't flood again. Prices tend to rebound. People forget. New people move into the area. But I think this is a slightly different situation where a buyer says, are you one of those folks in the reservoir? Oh, yeah, okay. How about I give you, you know, 20% less than what you're asking?
And
So
remember,
I think that question is going to be on everybody's minds for some period of time.
because when you sell the house,
You have to declare.
you have to make these declarations and you make these
Always.
representations, exactly. And if someone asks you a question, you've got to be honest with them about the condition of the home, or else they'll come back to you some later date and will bite you, okay? So you have to be honest about that. Was that your question?
That was it,
I
yeah.
thought so. Ma'am.
Declaration.
I have another question.
Sure.
For example, we are getting compensation because they store water in our properties, right? And what if in the future they do it again? Will they say, we already compensate you because you got flooded, or we can sue them again?
So the way, well, like a lawyer answer, it depends. The case that we're bringing right now is for this one event. If they flooded again tomorrow and you injured and took property from you again, there would be a second suit. What could happen, okay, what is a feasible result of, not likely, but a possible result of this case is that they say, oh, we are condemning these areas and we want a flowage easement, they call it, which is basically a fancy way of saying the right to flood you. But the cost of that, I think, would be very great. You see what I mean? And so your recovery would be astronomical as compared to just your current injury.
I mean, if
So-
the Corps of Engineers knocked on your door tomorrow and said,
Right.
we want the right once a year to store flood water in your home, in your bedroom, in your living room, how much should we pay you for that? What would you ask for? The entire value of the property.
But that's-
Yeah, I'll keep the property, but you pay me for the full value and I'll just keep living here.
And that's an important concept again on this takings, because the way takings usually happens, a condemnation case, is they say, okay, I've got this field, I want to build a highway, or we want to reclaim this whole waterfront for a park or whatever, and they knock on your door and they say, hi, I'm from the government, I would like to take your field from you, I'll offer you X dollars. You say, great, thank you, okay, then job done. Or you say, no, I'm going to, and you have a lawsuit about what the value of the property is. That's a condemnation case. This is a reverse condemnation, where they take it first, and then you fight about what the price is. So that's really, I mean, again, kind of boiling it down, what this case is about. They've already taken the property. Now we're trying to find what the price is. All right, they'll say, oh, we didn't really take it, it doesn't count, we have one freebie, whatever. There's all kinds of arguments that they'll say, why it's not a taking, but you feel confident in our ability to show it's a taking, and then the next question is again, what's the value of that to you? And so if what they say is, oh, we're going to come and take a flowage easement, thank you, thank you, I still like to live in my house, but that's a huge difference in just putting me back to where I was before, because they didn't have a flowage easement before. If they had done it sort of quote unquote correctly, they would have got a flowage easement over all that arc of land. And then when you bought it, they would say, oh, by the way, you might get flooded every once in a while. And you say, oh, well, no, thank you. Or, yes, but I'll pay a lot less. But you paid for the whole use of that land. Okay? And then you own the whole use of that land. And and they've taken that from you. And that's the taking. Does that make sense? Sir. The question is, do we have, our contract says we'll pay expenses, and does that go to, even if we have to go to do individual cases in the whole 9 yards? Yes.
How would you get compensated for your expenses?
So there's a statute by which if you sue the government, you and I represent you, we sue the government, we can collectively seek reimbursement for the expenses of that from the government. So you would get your damages. Right, exactly. So there you get your damages, and then we also say, by the way, it cost us, 10 grand to bring your particular case on just expenses, experts, whatever's apportioned to you. So, we want your $200,000 in personal damages plus another 10 grand. So we would take that 10 grand, okay, and then we would take, frankly, 25% of your 200. Does that make sense?
Yes.
Yeah. Sir.
Other firms are trying to get more clients just like this, and if it's certified as a class, you guys will be doing all the legal stuff, correct?
Well,
You'll be presenting the case, and then it'll be certified as a class, and then, if the other people are going to say, we'll take 20% as opposed to your 25.
So let me answer. The question is basically as between other lawyers and us, who's going to be running the case or something, right? Is that, I think you're understanding, or that's my understanding of your question. Remember I told you how there was 12 lawyers that were selected for leadership, 6 down and 6 upstream. Of the 6 upstream, that gets broken down into 2 sets of 3. 3 lawyers are assigned the job of handling motions to dismiss and jurisdictional issues, all right? So that's kind of earlier in the phase. And 3 lawyers are assigned to handle the liability, which will run through the end of this, this phase here. Of those 3, Charles and I are 2. So we are going to be the lawyers that try these cases that are up. And then the third one is a fellow by the name of Army Easterby, and his appointment was designated to represent the individuals who may not opt into a class. Because when the court first heard all the argument about leadership and structure, there was some people that said, well, maybe the people don't want to opt in. And so she appointed Army to sort of represent the interests of people that may not want to opt in. Now the reality is, and number one, we're working with Army all the time on sort of how to prove the case up. Number two, we have individual clients And the way I think, the way we structured it is the best for everybody. So we achieve a class resolution for the entire group, and then we get our clients lined up for their individual damages as well. And I don't view that as better for the class or better for the individuals. I view it as the best logistical way to get to the end result soonest. I hope that answers your question, but to your specific question, I think.
Yes, we're going to be doing all the work.
It's us. Well, not all the work, it's not fair. We three lawyers, Army, Charles, and me, are the people that were designated to carry this case through liability.
So these other attorneys really aren't putting in any work.
You're not gonna hear me say bad things about other attorneys.
We can do that.
And I'm doing something also.
Again, that's my point, right, is that we're not gonna achieve anything, right, if we exclude people. We are always gonna be collaborative and bringing people on. Larry is absolutely a fundamental part of this group, okay? And even people that have clients that aren't in the leadership, to the extent that they can help us and want to work with us, we're welcome to do that too. But we are the three that will be standing up and saying, may it please the court, blah, 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 blah.
And we're also working closely with the other downstream counsel because there are common issues. So Monday morning, bright and early, there's a flock of lawyers, if that's such a thing, a squad of lawyers, a herd of lawyers, going down to Galveston, going over to the Addicts Field office, and we're going to be looking through, 200 boxes of documents as part of the discovery process, and we're all doing that collaboratively. So there is a lot of working together, and to the extent that we as leadership can reach out to other lawyers and say, hey, can you look at these documents, can you look at these, we're going to do that.
To the extent they're willing to help and do it too. I mean, it's our obligation, but we're absolutely bring people in if they can help and they're useful for us, and we'll do it. Certainly.
What sort of time frame are we looking at? Like, give us a date. I know you'd like for us to sign up today, but I mean, what kind of time frame are we looking at as far as signing?
So the question is there, I'll put it this way, is there a deadline or any kind of target date for which to sign up? I guess the only things I'd say that there's a few different reasons why sooner I think is better than later. Number one, our ambition to try and get everyone set up and going on damages is that's a pretty heavy undertaking. And so the further down you are on our list, right, you're just next in line on getting that done. And I'm not trying to prioritize, that's the only way I can prioritize anybody, on that list. So that's internally. I think big picture on a macro level, the more people we can show the government that are motivated, that are signed up and that are here, and they ask all the time, how many unfiled cases do you have? And they want to know the extent of what's going on. And I have the sense that there's a lot of people out there that are sitting on the fence. They're either not sure which lawyer to hire or not sure whether to get involved or not, or wait and see. I think on the wait and see thing, I would absolutely encourage you to sign with a lawyer sooner than later because of the whole, by the end of 18, we should have a liability finding, hopefully. You do not want, I don't think, to start at that point in trying to figure out what your damages are. I think you want to try and get that ball advanced as far forward as you can. That's my view, and that's my advice to the people that are signing up with us. As to which lawyer, I guess the best thing I would tell you to say is, talk to whoever you're dealing with and ask what their plan is, and ask what, you can look at the numbers, you can, the percentages, you can look at who has leadership positions, you can ask them what their litigation tactics are, their strategy. Ask them, if they have an answer better than what you're hearing from me, do it, I mean, I'm not, but I think our strategy for getting this case tried, I've thought about it a lot, and this is the best plan I can come up with, so.
And ask them technical details about the Corps of Engineers reservoirs, and you won't find anyone who knows enough.
We have a lot of good attributes, I think, in our team, and I'm it's sort of, I feel like the progressive lady, right? We're happy to show you, deal with whoever you should sign up with someone. I think it is entirely up to you who you sign up with, but I encourage you to evaluate the different offerings on a subjective basis. I think we stand up pretty well there. Sir.
Yeah, two questions on Lakes on Elder.
Yes, sir.
One is if
if we live there, do we need to sign up again? 'Cause
Yes.
this is-
So, okay, give me your second question, I'll answer it.
Second question is, in the happy day when all the money starts to roll in, LOE's gonna have to take care of the roads and, the common areas and stuff like that. At the point at which they're gonna allocate the monies to individual homes, how are they gonna do that?
Okay, so I'll
Or
take,
is it just everybody gets equal?
there's two questions, just so everyone understands the context. We represent the homeowners association for Lakes on Eldridge, just so as an individual client, the HOA. We have been in contact with several other HOAs, thank you, and have actually signed up other ones as clients as well. We have other ones that we're in talks with. My ambition there is just try and make them realize that we've advanced the ball well enough and developed a significant enough amount of intelligence about what their particulars are that they should come with us too. So, on the question on on the Lakes of Eldridge HOA, if you live in Lakes of Eldridge, your claim is different than the HOA's claim. And so you do need to sign up individually, okay? The HOA doesn't own your property, and you don't own the HOA's property, right? The HOA owns the common areas, and you own, inside that.
It's sort of representing that they're taking care of it for everybody.
Yeah, that may, I'll look at the message there, because that's not, and we'll clarify that.
It comes across that way, though, I see.
I very much appreciate the question, because that's not the case, and we'll just make sure that gets clarified. Because your individual claim is different, so yes, you do need to sign up individually.
My second question doesn't matter.
Yeah, exactly. The second question on how it gets apportioned, the money will go to the HOA and they'll do whatever they do, and whatever impact it has on your taxes is or their, your dues or whatever it is that it is a separate issue. I'll just say on the HOA thing, I've sat in different meetings and I've heard HOAs, talk about reaching out to their constituents and raising the dues or whatever to pay for these damages. And I just encourage y'all to say, well, you should sign up and sue, tell your HOAs they should be suing. They shouldn't just tax you, right? Because, they have a claim. So let's make sure that everyone understands that they have a claim. Okay, sir. I told you I'd go to you next. I'm sorry. You had a question?
Yeah, so my question is regarding the guidelines for the damage. So do you have any guidelines what damage are covered? Because we said for a medical issue, if you hurt yourself or something, it's not covered. Do you have any guidelines what is covered and what's not covered under this lawsuit?
So the question was, I think, what category of damages are recoverable or not? The distinction that Charles made earlier, I think, is the biggest difference between what people think in their minds, like I can win in a lawsuit and not. Where if I get in a car accident, right, and I might have emotional injury, I might have personal physical injuries, those types of things, I don't think play into this. I will say that your time, all the time you spent trying to rebuild your home, that's valuable, and that's part of the recovery too, because you're effectively your own general contractor, okay?
Let me say,
Yeah, Larry, this part.
that's why we brought on the appraisal experts that we did, okay? They are top of the line. And so for our clients, our appraisal experts will be working with our clients to figure out what are the damages that you had that are recoverable. And they may be different than what someone else had, but they probably will be. So for each client, we're gonna figure out what kind of damages we think are recoverable for you and for you and for you and for you. And we've got, like I said, the guy wrote the book on how to figure out those damages.
But fundamentally, it's a property takings case, and so it focuses on property rather than personal injury. Does that make sense?
Do we pay extra daycare or any other stuff that's not covered, or do we have to sign first so we can understand what is our situation first and period, or we have some guidelines we can better prepare ourselves and have the receipts ready as we said?
I think you're going to have to, because that's kind of collaborative, we're going to have to sit down with you and understand what your personal situation is, and before we can tell you, yes, this is in or not in, to be honest with you. That's my answer to you, Mary.
What I've been telling people is we have a meeting with our damages expert on the 9th of February, and so we are all, as attorney teams, going to have a much better idea of what this list is to give you.
Yeah.
And so after that meeting, we will be working with all of our signed clients on whatever we develop from our meeting with our damages expert, which is in a couple weeks.
Okay. Are you guys including us who signed today in this email list, so we should start receiving email about this new list?
If you give us your email, you'll be on the list. You may regret it, but you'll be on the list.
Just don't tweet it.
No, I'll tweet at you.
Question over here. I've got a kind of a question. It goes to the flowage easement issue, because I actually plan to sell my house this year.
Okay.
So I guess as long as I put the language, I understand that in the sale docs, and I get paid, you know, for some favorable results, I get paid for the wreckage cost for this flood. I get paid for the diminution, I'm good. But where I've got a concern is, what if there's a case where they offer up a settlement where they say, well, if you grant us a flowage easement, you get all this money. I don't care if I sell it to someone, as long as I've recovered that. I don't care if they have a flowage easement, they get paid. As long as I've been paid for this diminution, this problem's here.
I mean, if you
What
don't,
I am concerned is if that gets in the way of collecting that money.
I don't see a universe in which it would. I mean, you know, if you don't own the property anymore, you can't grant an easement to the government at all. They have to negotiate that separately with the new purchaser.
That would be more of a
So,
condemnation to them.
You know, once you sell that property, you basically wash your hands of the ability to, you know, control what goes on in that property.
Other questions, sir?
Once someone signs up and with you all, what actions do you take going forward? What would we see going forward out of you all?
Okay, so the question is, what do we do with our clients once we sign up? Well, immediately you see you have the informational sheets. We start categorizing everybody, and then the next thing we're going to be doing is reaching out to you to collect documents that pertain to both establishing jurisdiction and also working up the damage aspects. Now, there is a lag between sign up and that happening, okay, because we're all, the volume of people coming in is pretty heavy, so we're focused on making sure everyone gets signed up and cleaned up there, and also when we get better direction from our damages experts, we'll have a better sense of what the outreach and intake should be for those matters. But I think within a series of, you know, probably 2, 3, 4 weeks, you'll be hearing from us about, here, send me this, that, and the other thing, and we'll be point-to-point contact with our, what we call them case managers, the paralegals basically, that will help move the cases along. So that's the outreach. And then the damages expert will give us a framework. We'll work with them to develop a framework, is a better way to say it, on how best to take that information that we get from y'all and then bring that up into some sort of damage calculation. So it's the interaction will be from our people to you about the specifics of your loss. You know, what do you have for, you know, your title documents? What do you have for your repair costs? What do you have for your property loss? What lists do you have? You know, that type of thing, and taking that in and then converting that into some sort of articulable damage action. Does that make sense?
How much water you had, how much water you had, whether you had flood insurance, questions like that are part of the basics of working out your individual case.
Okay.
Quick question, and I may have
Yes,
misunderstood.
thank you.
So when you're talking about the three of you, okay, Mr. Irvine,
Charest.
Charest? Okay, and it sounded like you said Army, but were you saying Larry?
No, Army is his name. He's the other fellow, A-R-M-I.
Okay.
I think it's short for Armistead, I think.
Armistead Easterby.
Yeah.
Armistead Easterby is the third, with Larry and I,
Okay.
co-lead counsel for liability purposes.
Daniel. So
Part of the same group?
So we have Charles's firm and my firm have partnered together so that, and Larry, I'm sorry, that's fair, I'm sorry, and Larry, our three firms have partnered together to represent in the client, you know, whatever individual clients we sign up. Separate and apart from that, in a sense, Charles and I and Army have been appointed as lead counsel for the liability case. And so the two of us were appointed for sort of like the full every aspect, and Army's appointed to protect the individuals. But as a business matter, I guess is the way to describe it. We three have a contractual agreement between us that we are going to work together for the individuals and also.
Each one of you represent a different law firm.
Yes.
Yes.
Yeah.
Thanks, sir.
And then there is another Larry,
Yeah.
and that's
Larry Vincent.
Dan's colleague, Larry Vincent, who was appointed to one of the three lead positions for arguing motions to dismiss and jurisdictional matters.
We good? All right, ladies and gentlemen, thank you. Sorry?
How large is your firm, and how many clients have you already taken on? And
Uh,
you You're gonna have 10,000 clients and
We won't have 10,000, I don't think.
4 attorneys working at 3 paralegals?
Yeah, right now,
Yeah.
well, we are actually hiring, I brought on a new lawyer recently and two case managers last week. I mean, we are increasing the volume of our sort of, client outreach, all right? We have, my firm has what I would call a fairly moderate, mass tort group, which is to say case managers that kind of deal with like cases where there's hundreds and hundreds of clients. Okay, so I have that infrastructure set up. I'm increasing the volume capacity of that to deal with the inflow of the clients we have now. So
I won't pretend to be part of a big firm. My firm has 4 lawyers, and so if you call our firm, you'll reach a lawyer, and you have our numbers. And Larry is part of a firm, Dunbar Harderer. The rest of his firm do immigration law. Larry does not do immigration law, so if you go to their website, don't be surprised to see a lot of information about immigration. But Larry is the flood expert and the flood lawyer at that firm.
Sir.
Quick question, if you sign up for a class action like this, is there not causing the issue of trying to sell the property? That there's a pending legal action regarding the property?
The question is, does signing up for a lawsuit impede the sale of your home? I suspect, I mean, I can't tell you what the buyer will think, but there's no limitation as far as I understand it about your ability to sell or the pendency of an action, because it's a claim that's personal to you. It's not personal to the property, is the best way to describe it. It's about your property, but the transfer of that property from you to another person doesn't transfer the claim that you have for the taking related to that property. And if you do sell, I encourage, again, Charles mentioned it now twice, I think, but we have sort of set language to just toss into the closing documents to make sure that you're not selling with your property your claim as well. So see us if you're planning to sell.